I'm Paul Castle at the Castle Law Firm. When I get retained in a felony case, for that matter, appointed to a felony case, the client asks me, how long is it going to take to get the case resolved? Some of my clients remain in jail for months at a time, and they are really eager to get the case done. And they ask me, when will they be able to take their case to trial? And they ask me about their right to a speedy trial. I explained to them it takes time to resolve a felony case. The reasons why it takes time to resolve a felony case are multifaceted, but at least I can think of a couple. The first reason is fairly ordinary. Felony cases, by definition, are more complicated, has more components, have more larger cast of characters, more detailed. So it takes the detectives, investigators, officers to longer to complete the investigation. It takes them longer to complete writing the incident reports, and they may very well have to send uh, a request to the North Carolina Crime Lab to get some lab reports completed, or sometimes they may have to enlist the assistance of experts, such as a medical expert, forensic psychologist, or a pathologist. So, of course, these experts also all have their own schedules, and it takes them time to complete those evals and reports. So let me bring this issue into a sharper focus. Suppose your felony case was the only case in the prosecutor's docket, and the prosecutor had no other case. Your case is filed, you will still have to sit for several months until all these reports are completed. All these reports is, in some sense, the evidence the state is gathering against you in your case. And we refer to them as the discovery or the discovery materials. In a felony case, unlike in a misdemeanor case, you, the defendant, is entitled to every bit of the state's discovery. You are entitled to see and inspect all those things. And the prosecution has the duty to supply you with all the discovery materials, and they just won't be ready to do that for a few months. So the first reason is fairly ordinary. It just takes time. The second reason is the economics of it. The state allocates only so much money to a given county. If we take the Onslow County as an example, there are about 6 or 7 prosecutors who handle felony cases, and each prosecutor has a huge caseload consisting of 3 to 500 cases, most likely. And of course, if there were more prosecutors assigned, 50 prosecutors, then each prosecutor would have 50 cases as opposed to 500. But again, that's the economics of it. Taxpayers' money is allocated. Only so much of the taxpayers' money is allocated to each county and to the judicial system of each county, and that's what it is. There is only so much money available. The same reasoning go to the judges and clerks and bailiffs. Only so much money is allocated to those court personnel, and in Onslow County, there is only one Superior Court judge sitting on the bench at a given time. Suppose they allocate the resources of the Mecklenburg County or Wake County to Onslow County, then there will be 10 Superior Court judges handling cases at the same time. There'll be 10 sets of bailiffs, clerks, and court personnel, and sure, their cases will be moving much, much quicker, but that is not the reality of it. Sure, Mecklenburg County, Wake County has personnel probably 10 times as large as that of Onslow County, but those counties also have caseloads 10 times as large as that of Onslow County. So it's just the economics of it. We don't have enough personnel, so your case will be added at the back of the line and you just will have to wait. But there are cases in which a felony case might get done really quickly, within a matter of weeks, and it's called a felony breakdown. That happens when the prosecutor agrees to reduce your felony charge or charges to a misdemeanor offense or misdemeanor offenses. And that can happen for a number of different reasons. For example, this is an assault case involving boyfriend-girlfriend, and the alleged victim girlfriend does not want to prosecute the defendant, the boyfriend, for felonies. Maybe they're getting back together, or maybe if the boyfriend is convicted of felony, that'll have consequences for child support. I don't know. But the girlfriend does not want to prosecute the boyfriend all the way for felonies. In that case, the felony charge will be reduced to a misdemeanor. Or in a different situation, suppose this is a sex case involving a minor child or children, and the parents don't want to put the children through the ordeal of a trial where the child or children would end up reliving the trauma of the sexual offense. In that case, the prosecutor may begrudgingly agree to reduce the felony charges to misdemeanors. And the defendant, for whatever reason, agree to the plea, and then it can get done really quickly in district court. Even under those circumstances, some discovery materials will still be provided to you as required by the statute, but it's not going to be to the extent to which you'll receive the discovery in superior court for a felony prosecution. I hope this has been helpful. If you have any further questions, please contact the Castle Law Firm at 910-347-3344 or www.thecastlelawfirmonline.com. Thank you for watching.